Hi there. So today we are going to discuss some of the topics that we didn't discuss earlier. So, so some of the topics will be in continuation of the topics that we had discussed earlier. So, for example, we discussed about the rule of ius dum generis, where generic words, are followed by more specific words. Then we give a specific meaning to the generic words. So if you remember that rule, as we had discussed earlier, there is another rule that becomes relevant, for us in that context. So it is possible that you have specific words, which are there, and then followed by other, not one general word, but general words. Then how do we deal with that situation? I mean, how do we give meaning to those subsequent general words? So that's something that another maxim by the name ridendo singula singulis deals with. So in a very important case by the name, an Irish case by the name MacNeill versus Crommelin, 1858, and in that particular case, it was, I quote from that case as I found in the book. It was said that where there are general words of description following an enumeration of particular things, so as we discussed in ius dum generis, so you had general word there followed by specific, you have following specific words. Here you have general words of description following an enumeration of particular things. Such words are to be construed distributively. Now, what do you mean by distributively? Well, let's see how it works. Maybe an example will be able to explain to you. But essentially, the idea here is that, you will know from the enumeration that one of the general word refers to particular set of words, the other general word refers to another set of particular words, and they are to be used in that context. And we are not to mix them up. That's the idea, and hence the word to be construed distributively and ridendo singula singulis. And if the words will apply to some things and not to others, the general words are to be applied to those things to which they will. So as we just discussed. So the general word will be used in the context of those particular words, with which it has a match. So that's why it is said that if the general words will apply to some things and not to others, then the general words are to be applied to those things to which they will apply, not to those to which they will not apply. So it has to, refer to the other matching words, the things that, it has some similarity with. And that rule, as was said in this particular case, is beyond all controversy. So one example will make it clear to you. So, for example, in this sentence, men and women may become members of fraternities and sororities. Now, how are we to understand this sentence? So men can become member of both fraternity and sororities, and also women can become member of both fraternities and sororities. That's kind of ambiguous, isn't it? Because it's not clearly saying anything. So how do we match these two sets of words? So we have to use the ridendo singula singulis, rule here. And that implies that the subject men should be applied to fraternities, because that's how it goes. And they form one particular list, as you can see, and women should go with sororities because they are a match. So we are to understand in the context of statutes as well, that the general words may have a match with certain specific words. Then they are referring, the general word is to be understood in the light of those matching words, and not to be understood in the light of those other words with which it has no match. So that's the rule here. So the difference with ejusdem generis is that in ejusdem generis you had one general word. Here you may have multiple general words. So that's how we are to deal with this problem. So one case might illustrate that very clearly to you. The case is by the name Bishop versus Deakin. So what happened in this particular case? So in this particular case, the defendant, that is Deakin, was elected as a municipal councillor in the UK, and she had been convicted of perjury and was sentenced to more than 3 months in prison 2 years before the election. So that's what had happened. She was convicted to more than 3 months 2 years before the election. So she was elected as a municipal collector. So that's the councillor. That's the election being referred to. Now, the opposition party brought this fact to the light, and in the light of that, sought removal of the councillor from the office 8 months after the election. So the problem was brought to the notice after 8 months of the election happening. And the relevant provision here that we are concerned about, you have to listen to it carefully, is this. It says, a person shall be disqualified from being elected or being a member of a local authority if he has within 5 years before the day of the election or since his election been convicted in the UK of any offence or ordered to be imprisoned for a period of no less than 3 months. So this is what it says. And obviously there was a limitation period of 6 months. Okay. So we have to now look at this provision once more. I'll break it down. It says a person shall be disqualified from being elected. That's the first part. A person shall be disqualified from being elected. Or it says being a member of a local community. So first part deals with election, okay, disqualification from election. The second part, disqualification from membership of a local authority. If he has, then within 5 years before, before the day of the election. So that's the first part of the second portion here, okay. Within 5 years of the day of election, okay, before the day of the election, okay, and or since his election has been convicted in the UK of any offence, okay, whatever. Now, how are we to read? So let's first break down the two different parts of the statute. First part refers to disqualification, okay. One is from being elected, the other one is from membership. And in the second part of the statute, you have two parts here as well, okay. What is that? Within 5 years, okay, from the day of election, prior to the day of election, before the day of election, and the second one is since the election has happened, okay. How are we to match these two portions here, okay, two separate portions of the provision? So we have to apply, in this particular case, the rule of redenda singular singulis was used. So what are the issues that we have? So you have, the first part, disqualified from being elected, okay, and then disqualified from being from the membership. And then in the second part, you see within 5 years before the day of the election, and then you have since the day of election. How do we match these two different sets? So in this particular case, it was held that with respect to disqualification from election, okay, which will it be applied? Okay, you see that in the second portion, there are two different parts. One says has within the 5 years before the day of the election, and then you have since the day of election. So you see that disqualification will not match, that what happens after the election. It's not a match, as you can see. And then in the first part, you see from membership, and that doesn't seem to, it was held to be not a match with, within the 5 years before the election, before the day of the election. So how has it been read? It was held that you were disqualified from the election, okay, if you have been, convicted within the 5 years before the day of election. So that's the disqualification for election, but not for membership. And then he says, being a member of a local authority. Okay, so with respect to membership, what would be the disqualification? That since his election been convicted convicted in the UK. So that's how the same has been applied. So says, so the said judge here says that all difficulty can be avoided. I mean, if we keep them together, if we read them as a whole, then the problem is theirs. But the same difficulty can be avoided by applying the well-known method of construction commonly known as ridendo singula singulis. Okay, and applying the first disqualification mentioned to first case dealt with, and the second disqualification to second case dealt with. So as I was trying to explain to you. So it was therefore held that a conviction prior to election, although a disqualification for the election, was not a disqualification for continuing to be a member. So yes, that's the clear match. So the disqualification would be if you have been convicted, okay, 5 years, within the 5 years prior to the election. And your membership would be if you are subsequently, disqualified. So that's why it was held that the conviction prior to election, although a disqualification for the election, was not a disqualification for continuing to be a member. And if the election was not challenged by the election petition within the time period, so the limitation period was 6 years, but the matter was raised much later, after 8 months, so limitation period applies. So the challenge cannot be with respect to the election, but only with respect to the membership. But the first part does not apply to the membership. So this person has not been convicted since she has been elected. So she gets to continue as a member. And since she has already been elected and the matter was not raised within the 6 months, so for that she cannot be disqualified. So that's the conclusion that the court had arrived at. Okay, so it says it was held that a conviction prior to the election, although a disqualification for election, was not a disqualification for continuing to be a member if the election was not challenged by the petitioner within the time limited therefore, that is the 6-month period. The member did not vacate the seat. So that's what had happened in this particular case. And then you can see clearly that the rule of ridendo singula singulis has been applied in this particular case. So the matching portion has been applied to the other matching portion. So that's the rule. So if you have any difficulties, feel free to write to me. So another important maxim here is it is known by the rule in peri delicto porior est conditio possidentis. So you can remember the rule as in peri delicto, okay, where two different parties to the matter, if they're equally at fault, what happens then? So when the both parties to the dispute are equally at fault, okay, then who has priority here with respect to any claim? Okay, so the understanding is that the defendant here has the priority, has this stronger ground. Okay, now when you apply it with respect to in common law with respect to possession, okay, if both the parties are at fault, so whose side would be stronger? The one who has possession of the property. So that's what this particular maxim talks about. So if both the parties are equally at dispute, then the one who is defending, the defendant, has a stronger position. So the idea is that here the law will not be ignorant of the illegality, the problem, the problem here, that is illegality of the transaction, okay, and that will be kept in mind in order to defeat the suit. And it will not be to maintain a suit. That's the idea. So in Taylor versus Chester, 1889, In this particular case, the plaintiff failed to recover money deposited with the defendant as a security for a debt contracted for wine and suppers supplied to the plaintiff by the defendant in brothel kept by her. So it's the illegality. So the plaintiff had failed to recover money, which which was deposited with the defendant here. Okay, Chester. For what? As a security for debt contracted for wine suppers, which is to be supplied to the plaintiff by the defendant in a brothel kept by her. So that's the illegality, and because of that, the plaintiff failed. Although the defendant here was at an advantage. So the idea is that if both the parties are equally at fault, then the party which is in possession, if it was with respect to property, gets to retain it. And you might have come across this principle in many different places. So in law property, the idea is that here, because possession itself gives a certain kind of right, so that means if both the parties are equally at fault, then the possession here would put the person who is in possession at an advantage. So in an Indian case by the name Ambalal Karshanbhai Patel, sorry, versus Varshasutra Farms Limited. So don't worry about remembering names of these cases, as long as you remember the rule. I can't remember this name of this case. So in this particular case, 2007 case, it was the court referred to this particular rule, okay, this particular maxim, and then said, where the parties are equally in wrong, the condition of the possessor is better. Where a certain person transferred her land to a near relative, benami, so that's the problem here, in order to defeat her creditor. So another problem here. And continued in possession of the same for a long period, and subsequently the heirs of the benamidar turned her out of the possession. So possession was taken by the benamidar. By asserting their rights, and the rightful owner brought a suit for a declaration of her title and for possession of the mean profits. So in this particular case, you see the problem from both the sides. Benami transaction is one problem. Then the other side, the problem was to defeat the creditor. Okay, so you have problems here. So both the sides here are in pari delito. So it was held that original transfer was tainted with fraud, and that the maxim in pari delito potior est conditio possidentis would apply to the case. And hence, on the facts, it was held that the original owner was entitled to the possession of the property, for damages and mean profit. Okay, so that's what they get, but not for the declaration of her title to the land. So that's the defect. I mean, if you are at fault, then there will be certain conditions. If both the parties are at fault, then the party which has possession has an advantage. So yeah, to that extent only you have the advantage. So as we were discussing, the party which has the possession has an advantage over those who do not. So this is the application of this maxim. So it kind of goes with certain other maxims that we discuss in law of equity. He who comes to equity must come with clean hand. So here the same thing is applicable. Two parties are at fault equally, but one party is at an advantage. Here the case of possession. So obviously the matter will unbalance, go in favor of the one who's in possession. So yes, that's what the idea is. And you have to remember that the law will take notice of an illegal transaction to defeat a suit, as you can see here. Okay, it is never to maintain one because it is based on illegality. So that's the idea. And one more maxim that you have, there's not really much to discuss because we have discussed that already in jurisprudence, so there's no point discussing that again here. And it is known as jura naturae sunt immutabilia. So jura naturae sunt immutabilia. What does it mean? If you remember, we said laws of nature are unchanging, eternal, immutable. That's what's being said here. The laws of nature are immutable. So yes, I don't want to go into any more discussion with respect to this because we covered this already in jurisprudence earlier. One more important rule that we need to discuss, I will just introduce this to you. You will understand that, then you can have a look at other cases as well. And it goes by the name, and I referred to this earlier as well. So it goes by the name Contemporanea expositio est optima est fortissimia in lege. Okay, what does it mean? So think of a situation. Okay, so a transaction has happened between two parties. Okay, they entered into some contract, okay, with respect to whatever, and it has happened a long period ago. Now, for us to understand from the document, okay, documentary proof of that transaction, how do we understand what had actually happened there? Well, you have what is there in the document, the words as written in the document. That's there. But then, if that were not sufficient, what else would you look at? You may look at something else, okay, not within the document, but from certain other surrounding facts. So, for example, how the parties behaved in the light of that transaction, and that may then help you in coming to true meaning of the stipulations in the document. Okay. Now, those extraneous facts are, contemporary facts of this transaction that has been entered into, that you find in the document. So those are kind of external aids, as you can see, because those are not from within the statute, but from certain surrounding facts. So those are kind of external aids. But they are contemporary to when the document was created. So, and they could very much be of help in interpretation, coming to the true intention of the parties. Now, the same could also be applied when it comes to statutes. So, certain statutes are very old. So, if the rule applies only when the statute is ancient in origin, okay, because if the statute is very old, it is to be understood in the context of the time and place when it was, and when it was enacted, and how it was understood, how the words were understood then. So basically, the words are to be understood in reference to the time when the statute was passed. So this is something, as you can see, applies only to ancient statutes, because it is only in the ancient times that the meanings of the words were very static. But in modern statutes are created in a much more fluid way, because the society changes much more today than it did some 300-400 years ago. So that means the words are also used in such a way that it's able to accommodate changes happening in the society. So the presumption does not really apply in case of modern statutes, because modern statutes are fluid in nature, and that's done quite often deliberately. And even when it comes to ancient statutes, if the words are plain, unambiguous, then those external factors, okay, those contemporary exposure, okay, will not be justifiable. If the words are plain, only one meaning, then obviously that will not be changed by looking at the context of the time when the statute was enacted. So in a case by the name J.K. Cotton SPG and Weaving Mills Limited versus Union of India 1987, it was said that unless contrary intention appears, an interpretation should be given to the words used to take in new facts and situations if the words are capable of comprehending them. So that's the idea, that when it comes to modern statutes, the idea is that, well, the times change and law should be able to accommodate the changes that happen because of passes of time. So the rule does not really apply when it comes to modern statutes, but when it comes to really old statutes, then interpretation, meaning of the words, unless they are plain and unambiguous, then the meaning is given in the light of other contexts. Okay, so all those extraneous aids then become relevant. So that's so these are some of the other maxims and rules that I thought you need to know, and these are quite easy to understand, as you can notice. So that's it when it comes to all the maxims and rules. We have just one more topic that I will deal with in another class, and that will be it with respect to all the concepts.